We'll hear first from Philip Lowe, who has been a constant in the field of competition for many years, and then from Roger Alford at the department, from Judge Singh, and from Superintendent Alexandra, if you don't mind my just saying Alexander. Okay. So Philip, would you get us started, please? And after the four have spoken for 10 or 12 minutes each, we'll have some crosstalk and then open it up to the audience for questions.
Well, thank you, Doug, and thank you very much to Leadership 2018 for having me here. I'm going first not out of arrogance, but because unlike my panel colleagues, I no longer have the constraints of public office, and I can maybe stimulate our discussion by making some uncontrolled and provocative remarks about international convergence in antitrust. I'd say there's a lot of progress been made over the years, both in institutional design, in due process, particularly in merger control and anti-cartel enforcement. But I want to try and relate some of the remarks which were more skeptical now to the core issues on antitrust enforcement and the interaction with IP law and the whole process of interaction between IPR, innovation and competition. Now, if you've got more than 100 jurisdictions in the world, you've already got a problem of coordination, a simple practical problem of coordination. Never mind the plethora of different legislative frameworks and the different relationships between court procedures and administrative procedures, different processes, different procedures, different timelines, both for antitrust and IPR. And other regulations may intervene in the balance, whether it's on data privacy, national security issues, and as was mentioned earlier this morning, some jurisdictions still persist in trying to regulate prices, however ineffective that may be. Prices of royalties, prices generally. In principle, one would assume that each jurisdiction looks after the effects of a conduct or a transaction on its own territory, but things are obviously more complicated. Even irrespective of the definition of where the market is, remedies can often be more effective if they cover a number of jurisdictions rather than be balkanized. Now, it's no secret to any of us here and the eminent lawyers who've had experience that markets are increasingly global, in particular in the IT fields, with complex systems and subsystems at the basis of many products and services, especially in the IT sector, but also cross-cutting in all sectors. Hence, in principle, the importance for business of providing some ground rules internationally as to how antitrust and IP law can interact positively for the benefit of both business and consumers. It's essential for a vibrant digital economy. Disruptive technologies at the basis of Schumpeter's process of creative destruction depend on that disruption being carried out in an orderly way and protected. Now, the challenge of achieving some convergence in law and policy, at least in devising remedies to antitrust problems, is an important one. Even at a jurisdictional level, that may be difficult. We've talked this morning about hold up or hold out, or the priorities at a US level. In Europe, there are frequently differences of view between the Commission and some of its national competition authorities in the European competition network. In India, I believe too, the Competition Commission sometimes has a different opinion about injunctions or about other measures than the courts. Now, we try, and we have tried in all our jurisdictions, to provide guidance or guidelines. There are international guidelines in the US, but they mainly talk about the process. Ideally, if we're to achieve some degree of convergence internationally, we have to put on the table guidelines or guidance as to how we think things should be done, and then we should learn from each other and draw the best practice from that. Now, the European Union has produced for many years guidelines on horizontal agreements, which have been updated regularly, and it has a recent communication on standard essential patents, notwithstanding the perceived potential for antitrust mischief in that respect, but it does attempt to provide some degree of clarity on issues such as disclosure and the criteria on which injunctions can be successfully or not successfully pursued. In addition, we have something in Europe called the IP Rights Enforcement Directive, which is designed, I'm not sure it achieves it, but it's designed to ensure that remedies for violation of IPR remain equitable and proportionate, both from the point of view of innovators and investors and from that of implementers. Now, court decisions bring some kind of clarity for business, but court decisions at the European level are quite rare. So don't look at the court case law from Luxembourg as a definition of European competition policy. You'll find some quite archaic decisions there, which I have been already quoted as saying we should try to update by slightly more appeals, but the incentive for appeals, whether on mergers or antitrust, remains limited. Now, we all want to produce the right balance between rewarding innovation through protection of IP rights and stimulating follow-on innovation, competition, and consumer welfare. We know that standardization can help incentivize and propagate innovation, including licensing of standard essential patents on FRAND terms. But the challenge of finding that right balance is by no means confined to SEPs, in my view. It applies to patent protection on the one hand and competitive circumstances on the other as a whole. Now, 20 years ago, the debate on the potential for international convergence in antitrust as well as IP law was a transatlantic one, dominated by the US agencies on the one hand and European agencies on the other, probably quoted mostly the European Commission and national agencies such as, at that time, the UK Office of Fair Trading and the Bundeskartellamt. Today, the debate involves a number of other prominent antitrust agencies. I'm not talking to you about the tail of maybe 30 or 40 smaller agencies. But it involves in particular China, India, Brazil, Korea, Japan, and dare I say it, my own country, the UK, will also soon have a separate voice from the EU, which may or may not complicate things. New ground is being opened up, for example, in India, but the comity challenge is therefore much more difficult. In addition, the debate 20 years ago was about international convergence in antitrust alone, whereas today, as we also heard this morning, we have to look out of the antitrust silo for convergence in antitrust, wider economic and social legislation, as well as intellectual property law. This requires, again emphasized this morning, a lot more interagency cooperation within jurisdictions, even before we get started in terms of international convergence. Now, ideally, there should be much more progress. That's a long-term process with work to be done, I believe, in the OECD and in the ICN as well as by cooperation between SSOs and international bodies. Moreover, if the effort is to have value added, the result can't simply be a lowest common denominator of general objectives and common processes. It's got to have teeth. More immediate progress could be made in further cooperation in devising remedies which are consistent between each other and make sense in different jurisdictions. There are still obstacles: due process, timelines, cooperation of the parties, consent of the intervening parties, and some of them are very strong. We also have to deal with the incentives for forum shopping, for regulatory gaming and capture. And it was emphasized very strongly by the first panel this morning that we should be careful that the big did not squash the small. I'd just like to add here that a lot of the discussion around IP, IPR and competition law enforcement relates to the big challenging the big, and not just to the big challenging the small. Some of the major cases coming up, major issues, relate to competition in litigation between major corporations. Let's not eliminate that from our discussion. Above all, a key challenge in antitrust enforcement in IT today is, on the one hand, as I think Jorge Padilla has emphasized earlier, we need to research problems more deeply, more holistically. We need to analyze the potential problems at each layer of the value chain, look at the overall vertical impacts as well as network effects, etc. On the other hand, if an agency, an antitrust agency, is to intervene effectively in a market which is fast-moving, it needs to do it in a time frame which allows it to help solve the problem as originally identified, and not to impose a remedy when the market has already moved on. At the same time, it should not intervene too quickly if this risks damaging competition rather than helping it. This is a challenge shared by all agencies, including all of the 135, and it's indicative that frequently younger agencies rush in where angels fear to tread. So international convergence certainly is a priority to make markets, global markets, work. International convergence requires convergence of policy and convergence of agency policy inside jurisdictions, but also requires an effort in international institutions to make it work. Convergence in court decisions is an even greater problem, because without, first of all, an attempt at convergence in legislation on more cooperation between agencies across jurisdictions, the courts will have only questions to ask rather than solutions to propose. Thanks.
Thank you, Philip. Roger?
Thanks for the opportunity to be here and to speak with you. I am honored to join you on this event, and I heard a lot about this organization, and I'm very impressed with the nature of what you're trying to accomplish. I think it's a wonderful example of the sort of developments and creativity that is going on in terms of getting think tanks and law firms and others to think through carefully about empirical research about the relationship between antitrust and intellectual property. I'm an academic, at heart, and so I'm in a strange position here speaking on behalf of the U.S. government. I tell people that it's a strange thing to be an academic in my current position, because as an academic, there's lots of things that you want to say, but no one wants to listen. But as a government lawyer, everyone wants to listen, but there's not a whole lot that you're allowed to say. There's only so much that I'm allowed to say. I've never had my speeches and articles vetted so carefully as in my past few months. But on the other hand, probably I'm saying stuff that is more coherent than I've ever said before. So I'm thrilled to be here and to have such a strong team to support me. Just before I talk specifically about comedy and extraterritorial remedies, I want to just reiterate what I've said before in numerous other venues, and that is that Makan Del Rahim is incredibly committed to international engagement. He says that I have the best job in the Antitrust division because I get to travel around the world and engage with my colleagues around the world. What he doesn't say is that I fly 15 hours coach on a regular basis. So that's not the best arrangement. But I do, once I get there, have an amazing time. I also have a great team with me. We have 3 people in the front office that are counsel in the office that do international, including Brinkley Tappan here that is with us. And then we also have a significantly enhanced international section. And we also have liaisons in the other sections that are doing international. And so we really are genuinely, creatively trying to think through how we do international engagement in a more effective and productive way. And that has been evident in the number of stakeholders that want to come and meet with us. It's also evident in the number of stakeholders that we proactively are reaching out to. We do truly want to engage in these dialogues with you and think through them. I think that the issue of extraterritorial remedies is one of the most significant issues for antitrust enforcement. It's just the nature of the beast is that with so many agencies around the world, they found their leggings, right? They are now at the point where they really are beginning to flex their muscles. And when they begin to flex their muscles, they're going to do things that are going to raise alarms with certain other jurisdictions. And so we are at the point where there are many, many agencies that are thinking strongly about how they want to vigorously enforce their antitrust laws. And so that's, in many respects, a very, very positive development. But it also means that we have to think through and ensure that they do that in a way that conforms with best practices. So it's a very fruitful time, in a way, in terms of dealing with the question of extraterritorial remedies. So, I would encourage you to read Makan's speeches, read my speeches on some of these issues. I just will say a few things about some of the things we're focusing on and what we're thinking through in terms of international comedy. First and foremost, if you haven't done so already, I encourage all of you to sort of think through and look through our international guidelines that we just promulgated in January of 2017. Those guidelines are a result of months and months of effort by the Antitrust Division and Federal Trade Commission. There's a lot of new things in there that we discuss, a lot of information on international cooperation, investigative tools, confidentiality, types of information that we exchange, waivers, and the like. We also talk about in there the application of U.S. law to conduct involving foreign commerce. So we try to actually articulate the U.S. Position on the FX doctrine and how we apply it. And we talk about comedy in there at some length, which I'll refer to in a minute. We also deal with foreign sovereign compulsion, which of course is a major question. Both comedy and foreign sovereign compulsion are before the Supreme Court in one way or another in the vitamin C case. So we're watching that one very, very carefully. As an aside, I also strongly encouraged you to read our brief in that regard. That was very carefully thought through in terms of what we said in the vitamin C briefs. And so it's an unusual case, but it's something I think is useful for you to look at. And then we provide a whole range of different examples and illustrations in those guidelines. So I think one thing I want you to take away is if you haven't really tried to digest and think through our international guidelines, I strongly encourage you to do that. In terms of comedy, my basic sense of comedy is that with the proliferation of the effects doctrine around the world, it's less and less likely that we will have situations where there's not legitimate authority that is being exercised. There are many, many instances where there's global businesses that are engaged in a conduct around the world that is sufficiently direct and substantial that it legitimately results in the invocation of jurisdiction by different competition agencies. And so I don't think, even though when I was a grad student, the effects doctrine was hotly contested, I don't think the effects doctrine is particularly contested around the world. It's been exported and embraced, and therefore I think in many, many situations we're living in a world of legitimate exercise of authority in situations where there's concurrent authority and therefore potentials for conflict. So that's the one thing I would say, is that I think comedy in the context of jurisdiction, I think, is different than comedy in the context of remedies. And we should make that distinction, and we should sort of wrestle with the distinctions of how we do comedy in the context of jurisdiction versus how we do comedy in the context of remedies. I think in the context of jurisdiction, there has been a tendency to take a fairly narrow approach, at least since Hartford Fire, to take a fairly narrow approach to comedy and sort of think about it from the perspective of a true conflict, in the sense of, inability to comply with the commands of separate jurisdictions. But I think in the remedy context, it's problematic to take a very narrow definition of comedy and to simply ask the question, is there a true conflict? Because it would be extraordinarily uncommon for there to be a true conflict in a situation of extraterritorial remedies where one jurisdiction is commanding that you perform a certain type of conduct and then another jurisdiction commanding you do the opposite of that, right? That would be extremely rare. I'm not saying it would never happen. I'm sure some of the lawyers in the room could cite a couple examples maybe, but it's not a common scenario, right? It's much more common where one type of conduct occurs that is being prohibited by one jurisdiction and is viewed either neutrally or positively by other jurisdictions, right? And so if many jurisdictions say that this conduct is pro-competitive, for example, and you can define how they make that statement. Do they make the statement simply by approving the conduct and not taking action against it, or do they affirmatively have to say something that we believe this conduct is pro-competitive? But in any event, one jurisdiction is either neutral or positive about the conduct, and other jurisdictions are negative about the conduct, and then how do you balance that? And so I think the answer in doing that is that we should move beyond case cooperation to move more creatively to thinking about policy coordination, which is to say, if you look at the sort of factors that are embedded into the international guidelines about what you are supposed to look at, among the things that you're supposed to look at are the interests of affected jurisdictions. That's a factor that you're supposed to look at in the comedy analysis, which begs the question, how do you know what the interests of the affected jurisdictions are if you don't pick up the phone and talk to them, or at least make some effort to identify what their policy concerns are about a particular issue? So I think where we should be heading in the world of concurrent authority with the issue of remedies is that we should think carefully about comedy analysis, which includes, among several things, careful consideration of the interests affected interests of other jurisdictions that have a legitimate concern about the issue. And so I've been advocating that we develop relationships with other agencies where they reach the point where we can talk to each other privately, diplomatically, about remedies that we're considering that transcend the typical scenario of simply case cooperation where there's merger reviews going on by both agencies, right? That happens a lot. There's a lot of very, very productive comedy analysis that happens where there's case cooperation and both agencies are looking at the same situation and they're talking through remedies. That's a quintessential example of successful comedy. But what happens when one agency is taking on a case and there are no other agencies that are taking on the case quite the way that this agency is it appropriate then to engage in careful policy coordination in the fashioning of the remedies? And I would submit in the world of global licensing that certainly is the case, that should be happening more often and that we should strongly encourage that. That doesn't mean, of course, that they have to then change their result or modify their remedy, but it means that they have to take a careful consideration to the positions of those other agencies with respect to that particular issue. that's the way comedy works. It's one factor among many factors that you engage in when you do your analysis. So I think that what I think we should be moving forward with respect to comedy is move beyond case cooperation to move to a situation where there's policy cooperation or at least coordination. Luckily, in the antitrust world, we meet all the time. I'm amazed how often we meet, right? I saw you 2 weeks ago, right, in India. So we meet all the time, right? Way more than I expected. And so there are lots of opportunities for bilateral meetings on the margins of various ICN or OECD or ABA spring meetings to have these sorts of conversations, right? So, and I think that should be strongly encouraged. So I think that's one main thing I would say. The other thing that I think would be interesting to think about would be to move beyond comedy analysis in sort of the policy coordination, but also like think about encouraging best practices with respect to extraterritorial remedies. And that might mean, for example, encouraging other agencies that are emerging as really major players to develop their own international guidelines that talk through in a very careful way about the way that they're going to do their international guidelines, which includes questions about jurisdiction and remedies. I think that there's definitely room for more agencies to do international guidelines and to carefully articulate the way that they might do that. I also think that there is definitely room for the ICN and the OECD to take on this as a project, right? I think it was very beneficial at the OECD in December that we had a range of papers that were circulated about extraterritorial remedies, and that was very fruitful. But I think there was a sense that as a result of that maybe more could be done in this area with respect to both ICN and OECD taking on this as a project. Because we want agencies around the world to effectively enforce their laws. But we also want them to do it in a way that is sensitive to the legitimate concerns of other agencies around the world. And so how do you thread that needle, I think, is quite difficult. But those are, I think, ways that that I think are thoughtful and careful. The final thing I would encourage all of us to think about would be to have the business community, to have the various think tanks, to have academic scholarship, to have empirical work done, similar to what Chris Yu is doing and others on sort of procedural norms and standards. Think through about what is the proper way to do extraterritorial remedies with these agencies. And so an organization like this that promotes empirical research would certainly, I think, help us understand the way remedies can be done and should be done. And so I think there is a role for all of you as well in that respect. So I'll stop there.
Thank you, Roger. Justice Singh.
Thank you, Judge Ginsburg. I would first like to start by thanking the organizers for inviting me to speak at this event. And I also wish to thank the Government of India and the embassy here in DC for enabling me to come here and taking care of me here during my trip. I speak on the basis of my experiences as a lawyer and a recently elevated judge. I practiced in the Delhi High Court, which has been on the forefront of IP jurisprudence in India. And I'm now a proud member of that bench since May 2017. And I share the sentiment of holding public office, which was just reflected by Roger. And unlike my usual self, I would like to read from a prepared text so that I don't wander off from what I want to say. Last year, I received a book called Sapiens, which traced the history of humankind on planet Earth. It starts with the dynamism between physics that created matter, chemistry that led to various reactions between matter, and biology that started life. The beauty of this dynamism led to the greatest innovation that man has ever made, that is fire. It was fire that helped protect humanity from animals. It was fire that kept our ancestors warm, and it was fire which helped us cook food. Innovation began with fire, but over the thousands and millions of years, innovation was incremental. From fire to the wheel, it took maybe several 100,000 years. However, with the beginning of the wheel, the Industrial Revolution, printing technologies, Telecommunication technologies, the human mind has innovated at a breakneck pace. This pace surely was not even in the contemplation of human beings and was very different from what nature had implemented over the millions of years. The paradigm shift from the Industrial Revolution leading to the digital revolution is disruptive innovation. It has changed what we do when we wake up, how we talk, how we wish each other, how we plan meetings, to say the least. We check our smartphones before we brush our teeth. The time span with which innovations are happening in the digital era is unprecedented, as innovations tend to change by the year. For someone like me, who belongs to the generation born in a home without a refrigerator, mind you, I'm not very old, to someone who stood in lines for purchasing ration from home when essential items like sugar and kerosene were distributed by quotas. I saw the first black and white television in the 80s during the Asian Games, and I stood in lines for several months to get a landline telephone connection in India.
So did we.
To the 1990s or the early 2000s, which witnessed the telecom revolution in India, we've seen it all. If one reflects back on the cause for such innovation, which has led to benefit to human beings, there are two theories that support it. The first theory being innovation is free. It's spreading very fast and very quickly without inhibition. The second theory is the incentive to innovation given under patenting systems. There are several amongst us who believe and who question that granting of patents has curbed and stymied innovation, but there are others who believe that patents have, in fact, led to a more innovative ecosystem. Speaking for myself, the debate about whether patents are needed for innovation is long over, as patent systems are not merely prevalent, but well entrenched in almost all nations. Patents are recognized under law, and this process is irreversible, at least in the near future. The growth of industries in the developed world is evidence of the strength of the patent system and its benefits. The development of technologies led to quicker transportation, removal of geographical barriers, and easier communication. Patents initially result in controlled exclusivity in the hands of patentees, who decide how it is to be used, how it is to be exploited, and how to prevent others from using it. As someone said today, patents are negative rights. This concept of patenting and the rights that it gave resulted in the creation of a large breed of industries and corporations which have gone on to rule the economies of the world, create millions of jobs, leading to disposable incomes, in turn leading to more economic development. The development of mechanical technologies and communication technologies converged in the digital era and resulted in the innovations of convergence that we see today. A telephone is no longer just a telephone, neither is a television simply a television. Convergence has resulted in the phone becoming a TV, the TV becoming a phone, the computer becoming a TV and a phone, all of these becoming libraries, radios, and above all, platforms which unite. The digital revolution has resulted in uniting families, communities, people, languages, culture, above all, nations. The access to these technologies is the reality of today. It was not long ago that one was required to check while traveling out from India whether a particular recorder was a PAL or a CCAM technology. These differences have now been obliterated because of standard setting. Standard setting has played an important role in digital revolution, which involves almost every gadget that one uses in our daily life, starting with the power plugs, the domestic appliances, telephones, radios, Blu-ray players, DVD players, USB ports, data cards, dongles, air conditioners, CDs, smartphones. It is not just the products which have been standardized in terms of their basic features. There are a host of other products, whether they are laptop bags or hard disk covers, that have also been standardized. Thus, despite all the diversity, convergence in digital technologies has led to standardization of products. Such standardization not just results in convenience, but also a form of identity in human behavior. Gone are the times when one would enter a train and chat with the passenger on the next seat. Human traits of being hooked to the digital media are a uniform feature across the world. Social media, therefore, is actually, in that sense, antisocial, because we don't talk anymore. Standardized products are thus part of our everyday living and play a huge role in the manner in which human lives are going to be led. There are studies which have reported that an average teenager in an urban city in the world spends 2 to 4 hours on a smartphone on a weekday and maybe even 5 to 6 hours on a weekend. We need more and more of these devices for the burgeoning population of the world. How did this happen? Was it a miracle? Definitely not. It was the cumulative effort of thousands of computer engineers, software professionals, researchers who were able to share their innovations, which were also patented, amongst each other without any hesitation, which resulted in the creation of cumulative standards as we see them today. Every standard has behind it the hard work and labor of thousands of such persons. This was also possible only because greater protection and quicker communication led to unhesitating sharing of knowledge from which the innovators were sure of deriving benefits. The setting of standards is one of the biggest movements that has happened after the Industrial Revolution, inasmuch as if not for standards, there would be not an ease of communication or ease of human life. With the setting of standards came the big question as to whether if standards belongs to a few, would it lead to curtailing quick dissemination and concentration of wealth? The stepping in of standardization bodies at this stage to evolve principles such as FRAND, RAND, or whatever name one may call it by, has led to all patent technologies being spread far and wide with or without technology transfer. The principles of FRAND and RAND have, however, become the subject matter of long-drawn litigations, both in civil courts, before regulators, and also competition authorities. The interface between intellectual property and competition law has captured the imagination of regulators, policy bodies, legal experts, and corporations across jurisdictions, and India is no exception to that. While IP laws are well entrenched and are adjudicated on a daily basis in Indian courts, patent litigation in the area of SEPs is a recent phenomenon. While there are a few cases dealing with SEPs, since 2013, India has witnessed many high-profile SEP litigations in the field of telecommunications and electronics. In most SEP litigation, the models followed by Indian courts has been to grant some protection to the patentee and direct expeditious trial. The type of interim orders passed by courts include injunctions or undertakings not to use patented technologies, interim deposit of royalties in courts calculated as a percentage of the net selling price of the final products, interim payment of royalties to the patentee with a counter guarantee by the patentee, deposit of bank guarantees in lieu of payment of royalties with the registrar of the court, combination of deposits and bank guarantees. The general trend in IP cases, including SEP cases, is that they follow a typical timeline. There is negotiation, preparation of patents for litigation, interim orders, case management, witness depositions, and final arguments. In my experience, 90% of trademark and copyright cases in India do not go to trial and get settled at the initial stage. In patent cases, especially SEB cases, they do go to trial, but around the time when witnesses are to be called, they tend to get settled. I've been informed recently that the Delhi High Court Mediation Center has been used for pre-litigation mediation in a bunch of SEP cases with great success. In this process, a notice for mediation before litigation is issued by the Delhi High Court Mediation Center upon the request of the patent owner. This may regulate the conduct of the mediation and lesser chances of allegations relating to misuse of dominant power during negotiations. So bona fide negotiation has been the key hallmark of this. India, as you may be well aware, has the Competition Act, which governs anti-competition conduct. There has been a recent spurt in the number of disputes involving IP and competition law. These cases have been wide-ranging, from music licensing, distribution agreements for theatrical screening of Bollywood movies, licensing of genetically modified technology for cotton seeds, SEP licensing, Google advert programs, etc. In all of these cases, the common refrain has been that the respective IP statutes are self-contained and ought to be regulating the mechanism provided therein, and competition authorities have no jurisdiction. The Supreme Court of India has held that the CCI, the Competition Commission of India, is vested with inquisitorial, regulatory, adjudicatory, and advisory jurisdiction. In one of the first judgments involving IP and competition interface, the Delhi High Court held that the Patent Act, being a special enactment, would prevail over the Competition Act if there are irreconcilable differences. The court further held that the power of compulsory licensing under the patent statute is different from the power of the CCI to deal with abuse of dominance. The court held that patent laws define the contours of patent rights and antitrust laws prevent the abuse of rights, and hence there is no irreconcilable conflict between the patent statute and the competition statute. CCI would have the jurisdiction to deal with issues relating to anti-competitive agreements and abuse of dominance. The court further observed that because the patentees had involved in negotiations before suing, it cannot be straightaway held to be abusive conduct. Interestingly, the court cautioned the CCI that it has to maintain utmost confidentiality of information disclosed and follow due process in investigations. It went to the extent of holding that the CCI would not be immune for a claim of loss or damage if proper confidentiality was not maintained. Any malafide, capricious, unreasonable, or malafide conduct by the CCI would make it amenable to judicial review. The court observed that the CCI has to observe the high constitutional standards required by a regulatory authority. This decision is now pending before a division bench in appeal. Subsequently, in a case involving biosimilars, the CCI directed that a particular practice adopted by the patentee of spreading wrong facts in respect of a biosimilar drug was anti-competitive. The CCI, however, cannot look into issues relating to infringement, validity of patents, royalty rates, but has jurisdiction to look into abuse of dominance. Thus, competition authorities and courts operate in their respective spheres. How is the exercise of IP rights to be reconciled with competition? The best way to do it would be to ensure that there should be lesser number of reasons given for competition authorities to interfere. What are the uncertainties that exist in a patent enforcement process on SAPs? The first one, I think, is who owns the standards? How much do they own? What would be a fair compensation, i.e. a range? What would be the total payout for the implementer? And the code of conduct for technology owners and implementers. I personally believe that as part of the standardization process, a common platform of innovators and implementers ought to be created to determine these issues at the initial stage before the technology is successful. A code of conduct would also make implementers aware of the owners and the conditions under which technologies can be used. Once competition authorities have this ready data available, the same would govern the conduct of parties, and non-adherence to the same could be frowned upon. At the moment, there is a lack of uniform opinion on the conduct of parties. Decisions like the Huawei ZTE from the EU have emanated from different jurisdictions, but not all countries are governed by those rulings. There is repeated interference by governmental authorities in various countries in licensing negotiations, which is not a happy situation. Courts operate under the respective legal systems, and the procedures in courts are governed by fairness, transparency, and due process. That could be long drawn and unavoidable. Those who implement standards also ought to be aware that the very technology which led to the creation of their wealth would be totally annihilated if the process of standard setting is defeated. Licensing of patented technologies which form part of the standards should be like paying for raw materials to manufacture a product. The market has to determine what needs to be paid and in what manner. Negotiations of patent licenses should be a commercial decision rather than a legal one. If every patent license agreement is to be negotiated patent by patent, jurisdiction by jurisdiction, product by product, then standardization is a failure. India is one of the biggest markets for communication technologies. There are more than 1 billion subscribers in India, and this offers great potential for use of these technologies. It is the second biggest telecommunication market in the world, home to millions of English-speaking young internet users. Today, we see a large aspiring class which needs smartphones, internet connectivity, downloading capabilities, etc. Policy and law has to develop keeping this enormous potential in mind. If not for standardization, there would be isolation. Instead of integration, there would be barriers. Instead of convergence, there would be divergence. That would lead to lesser sharing, lesser prosperity, and concentration of innovative power and economic power. Such a situation would lead to a collapse of the development of innovative technologies, which is an unpalatable consequence. Courts, regulators exist for dealing with exceptional cases where disputes arise, but shifting of the burden of licensing to them would result in complete collapse. If there is no immediate reform in this area, the day may not be far off when digital technologies start vesting with tribes to immunize them from challenge, like in the pharmaceutical field. We may then go back to the times when each country had a different standard, different IP regime, local manufacturing, local sales, instead of the global ecosystem that now exists. Thus, I would say that it's only when IPR, which stands for intellectual property rights, also becomes innovation protection rights, that we would see the best growth of the intellect, leading to greater innovation, more jobs, and more prosperity in a balanced manner in the whole world, and not just in a few countries or a few economies. Thank you once again.
Thank you, Justice Singh. And, yeah. Alexander?
Thank you, Doug. Thank you for leadership having me here. It's a pleasure. So I have to agree with Roger. International cooperation, it's very important among the antitrust agents. And I think that we do this pretty well, but we have more room to improve, actually. And also we have a lot of opportunity to meet each other. And what I'm going to say right now is to explain a case that we judged like 3 weeks ago. That is a very good case about international cooperation. And in some jurisdictions, they have decided this case different from Brazil. But before we judge this, we did what Roger just said. We pick up the phone. This is the best way to cooperate. I'm sure that guidelines and everything, it's pretty good to be transparent and everything, but we gotta share our experience. We gotta pick up the phone and talk to our colleagues and ask what's going on over there. What have you seen a case like this?
Right.
Oh, I have this case here. What did you do? Because I have no idea what should I do right now. So, and this exchange of experience is pretty good. So in this case, is a case related to IP and antitrust. In this case, that showed in a quite particular way the relation between those areas. It was about uncompetitive conduct imposed by Fiat, VW, and Ford against the auto parts manufacturers. The vehicle manufacturers got the IP of the designs of the outside parts of the cars. And so, besides the design of the whole car that we call foremarket, the car makers also got the IP for each outside part of the car that we're going to call aftermarket, like lights, bumpers, external mirror, and so on. So the car manufacturers were being accused to abuse their IP right because they were going to the court against aftermarket companies that tried to copy the auto parts. This case started as a sham litigation case and changed it for IP abuse. The argument of the abuse was mainly that the car makers could not sue aftermarket companies because the IP right should protect just for market. Even though the car makers have the IP right legally registered of both market, for and after, the argument of the abused was that the car makers could not defend their IP right because it did not make any economic and social sense. And I will explain what happens. First of all, I want to just highlight that the market was established and working like this for the past 60 years. And suddenly, the car manufacturers start to sue the aftermarket company. Second, and regarding to the economic, and now regarding to economic and social issues, the Brazilian civil law says in the Article 187 that it is unlawful conduct the owner of a right that uses it clearly over its economics or social limits or without good faith. So, in a very general way, the main principle of the IP is to give someone the exclusivity in order to explore his invention. This is an incentive to innovation and investment. Regarding to the economic issue, the design of the auto part represents a very small percentage of the value of the car. It means for the complaints, it doesn't make sense IP right in this case because the investment was recovered in the foremarket and there is no innovation in auto parts designs. For the social issue, is also clear. There is no doubt that the IP right in aftermarket, especially in auto parts market, can cause lock-in effect, a monopoly, and consequentially increase in price. So socially speaking, it is also a very bad thing. Regarding, we are judging a conduct case. What CADE had to solve in this case? What should it do? The first question is, what is the role that CADE should play on this game? Can CADE convict the parties because they are defended their IP right? Can CADE only condemn them if find an abusive conduct? Did the car manufacturers really abuse their right? If we say so, where is the conduct? Is getting the court against someone abusive? How many cases do I need to prove that? Let's understand what abuse means and try to see if the party conduct matches. To consider IP right abusive, usually you try to identify excessive increase in price, a deliberated product shortages, to refuse to offer the product or service that is essential to another activity, evergreening practice, fraud to get the patent, tie-in sale, sham litigation, and so on. In this case, we did not find any of those. What the party did were to get in the court, that is a fundamental right in Brazil, as we talked yesterday at the dinner, to protect the IP legally obtained. But you might be thinking, okay, 50 cases, even if it's a fundamental right, 50 cases against one competitor can be unlawful. Yes, but that's not the case. Actually, for example, Fiat suited just one case. VW suited 2 cases against different competitors. Ford got in court more times, like 17 cases, but it was against several competitors. And by the way, the car manufacturers lost just one appeal in all of those cases. I'm sorry, but it doesn't look like IP abuse in a sham litigation way, sham litigation model. I want to be very clear here. That is very important to say that. I am not saying that to give patent to protect aftermarket is okay for competition. I'm not saying that. No, it is not. And we have many cases abroad related to that. What I'm saying is, this decision, it's not CADE's role. Who decides what is the economic and social issue of a patent and register the IP is the IP agency. After that, what we can do is just an advocacy role, and we did that. In the vote of the commissioner responsible for the case, there was a chapter of advocacy to the IP agency explaining the competition harm that it could cause. So the CADE's conclusion in this case was to close the case, even though we see a possible competition harm on the aftermarket. Anyway, we could not condemn the party because they were just protecting their right legally obtained without identifying any abusive act. This is a regular exercise of a right, and if the right should not have been given, it is a AP agent's role, not for CADI. So when we judged the case at the tribunal, was not so easy decision, like looks like, was 4-3. So very tight decision in order to close the case. And I didn't vote because when I was a commissioner, the case came up and I dropped my term and became a general superintendent where the case started. So it's for me, I don't have to do any disclaimer in this case because I didn't actually participate. I was just watching it. But I had my opinion that time, and it was also to close the case. For me, this is not an antitrust issue. There was not abusive conduct. Probably some harmful conduct because it shouldn't give the IP for this kind of case. But this is not a CADI problem. This is the IP agent's problem. So, and we cannot condemn anyone for defending the right that they have. So, thank you very much.
Thank you, Alexandra. I thought it rather interesting. Roger talked about, Philip, talked about the need for intra-national coordination among agencies, and we have examples from India with the court having to resolve the relationship between the Competition Act and the patent law, and now from Brazil, where you're able to decide for yourself not to intervene because it's a patent issue. Philip, did you have comments on anything you heard?
Well, first of all, I think that Roger is completely right. If we're going to have guidelines at all at the level internationally, let's start with the ones on basic principles of due process, confidentiality, waiver, and other things. That is, those are the terms of engagement for comity. Where it would be less, I remember discussing this very much on big cases which you know of when I was in charge, including large companies who no longer have a dominant position, but did at the time. And to get, for example, remedies in the interoperability area worldwide, when there was a difference of opinion about whether the remedies were required, was a challenge. So even if there is a willingness to discuss, there's not necessarily a willingness to put the hand in the fire. If you compared the the original consent decree for Microsoft on interoperability with what we imposed in the end in our Microsoft decision, there is not much difference. On the other hand, if we started to talk about browsers, where we didn't find at the beginning an appropriate remedy, I think it would take a long time, even in private, to come up with a good decision. The second thing is, I absolutely agree that there are several markets where it is absolutely essential that the major agencies in the world share as much as possible their view as to how these markets are developing in the sense of the competitive dynamic, let alone the IT markets, aviation, agribusiness. I mean, think about what's happening now today with the 2 or 3 deals either having been concluded or are being concluded, without the degree of understanding of what would be likely to happen if there were only 3 major corporations worldwide compared with 6, is something where it is absolutely essential that we come to good remedies worldwide, because there isn't really that much distinction between the effects for hundreds of millions of consumers. And thirdly, I think that the argument, the examples given on India and Brazil are really telling. I think it's interesting to see it would be interesting to see what the result finally is for Brazilian consumers. We've had cases like that. I think the US agencies have too, where in the end, not under IP law, but under other law, we were able to liberalize the aftermarket through antitrust action, particularly also through interpretation of the horizontal guidelines. Now, guidelines aren't the be-all and end-all, but they are the start of a process, first of all, of letting people know in advance whether they're on the right side of the law or the wrong side of the law, at least from the point of view of the agency, perhaps not from the point of view of the courts, but at least the point of view. So they have some degree of clarity, if not always a great deal of clarity. But secondly, to get into position of a policy convergence requires real research and real exchange of views about market development. And I think that would be, if the US, the EU, and other big national agencies are able to reach an agreement, an understanding about what is going on, then they can get round the practical obstacles. On many occasions, I sat with people like whose names you know, like Hugh Pate or Tom Barnett or others, and we knew that the court needed to take a decision in the US on a merger, where we had to take an administrative decision. How do you get round that, given the timelines, the time deadlines which we've all got? We did a lot of treading on eggs to make sure it worked. And that really is required to make it work. There are other areas, however, where we're bound to disagree, and maybe Roger is right. There are a number of areas we can disagree on the fundaments, but we could agree on the remedies, but not always.
Yeah.
Roger, you had something about what Justice Singh
Yeah,
said.
I agree with, especially I agree with that last comment, that there are many, many times when we can try to endeavor to agree on issues, but the remedies simply are going to be difficult to square with what other jurisdictions want to do. Just a few things I would say. I didn't really speak in any great detail at all about case cooperation, but I think there is just an incredible amount of work that goes into case cooperation. I've just been stunned at how much case cooperation we do. I'm going to have statistics for tomorrow morning at the deputies panel to sort of give you a sense of it, but it's really dozens and dozens of cases of real cooperation, and in some cases just countless hours of case cooperation. I'm just glad that the folks in Brussels no longer insist on speaking in French, given how often we talk on a regular basis. There's just a massive amount of cooperation that goes on, and a lot of that cooperation is honestly just trying to figure out how to make the remedies work for both jurisdictions. That's a lot of what goes on in the discussion, and so I do think it is possible, and it is happening on a regular basis. But I think you're right. I think there are situations. So we talked about Justice Singh on the phone when we did our preparatory call. What do you do in a situation in India where, from the U.S. position on IP, the IP holder has a right to make a choice to either work the license or work the patent or license the patent, or if they choose to do nothing with a particular patent that they may have. Whereas in India, the general, correct me if I'm wrong, but the sort of patent working law is such that there's an expectation that a patent holder will either work the patent or license the patent. They can't just sit on the patent, right? And so what happens in a situation in which you want to issue a remedy that basically requires a licensing of a patent because you find it to be anti-competitive to do otherwise, and we would say, that's essentially technology transfer, forcing of technology to a competitor. Essential facilities doctrine would frown upon that. And so how do we do a dialogue in that situation where there's such a sort of a divergence of understanding of what is required under competition law?
Okay, that's an interesting point that you raise because while there is a working requirement under Indian law that a person cannot sit on a patent and not use the technology, the courts are hesitant in granting licenses when the company doesn't want to grant it. I can speak from experience of a particular decision in the area of pharmaceuticals where it related to a particular respiratory disease and the drug wasn't being used in India in adequate quantities. And this Indian pharmaceutical company wanted wanted to manufacture and sell the drug, and the primary contention was that since the patentee is not using the drug enough or manufacturing it in India or even importing sufficient quantities, the company should be allowed to do that. So the court said no. I mean, unless and until the entire process of compulsory licensing is actually gone through under the Patent Act, the court can't direct a license to be granted. So compulsory licensing by itself is a very tedious and a long-drawn process under statute. But yes, the fundamental point being that in India, the general feeling is not to allow patentees to sit on patented technologies. But yes, the courts are not very comfortable granting licenses without the patentee's approval or consent, usually.
If a court does require licensing, then does it also set the price?
In the case of ACPs, yes, it does. But not in the case of non-ACP patents.
Alexander, anything you want to say about the things you've heard?
No, just I want to go back to the issue of international cooperation about the remedies. It's a very big issue. Also, we try do this, like call the other issues and see, try to put the remedy together. So in order to work in both agents, this is pretty important. So the other thing that I just want to add in about the relation of IP and competition issue, especially in this case that I just talked about, is that in Brazil you don't have the power or the enforcement to like license like compulsory the IP. The agents cannot do this, but we can do a opinion and say okay to the IP agents and say okay, this is uncompetitive. We recommend that you done with this license. You gotta let it go and not give the license, not give the IP anymore. So this is the advocacy role that we play in that case. I think that if we could decide to avoid the license, to avoid the IP right, we would do in this case. But we could cause some problem in the other jurisdictions because they're not going to have the patent in Brazil anymore, but they have it here in the United States or in might not other jurisdictions. So should be a big problem. So, but we close the case. So
We have a few minutes for questions and welcome them. Comments, even comments, but preferably questions.
I find that I'm intrigued by the idea of trying to foster cooperation by trying to broaden the dimensions. We see differences on policy. Are there other opportunities to engage in constructive conversations and build a more cooperative dialogue among agencies? Perhaps not by focusing on areas where we differ the most, but finding areas of common ground. And do you see those kinds of opportunities to build, again, a more cohesive competition policy that will benefit the companies that have to confront all the enforcement authorities across the world?
Well, I think the progress which has been made since we set up the International Competition Network, but also the work of the OECD Competition Committee has concentrated on the low-hanging fruit. And the low-hanging fruit is on due process, is on areas where, even though there may be a difference in the legal framework, like anti-cartel enforcement, I'm being accompanied by music, but I'm not sure from where, so it helps. There is a strong policy consensus on attacking cartels, and that's led to a lot of good work done on best practices, just as it has been on merger control procedures. It's interesting also to note that in relation to the generally, I would say, more populist mood in all our jurisdictions, that antitrust agencies have engaged in advocacy throughout the world to say, be careful as far as public interest tests are concerned. Try and concentrate on issues which you can identify and which are monitored, can be monitored and verified. And it was very interesting to hear Macon talk just now about that, and say competition criteria on the one hand, but if there are other issues to be dealt with in a merger, let other agencies look at them, whether it's CFIUS or whoever, but don't mix everything in one pot. Now, there, I think our advocacy role vis-a-vis, our, in the sense of the more experienced agencies, our advocacy role is surely very strong in institutional design, in the relationship between the agencies and the courts, in due process, and in those areas where one can clearly identify major consumer benefit and major national benefit from efficient merger control, efficient anti-cartel procedures. On the other areas, well, I tried for many years to get some degree of consensus inside the European Union on what we intended to prosecute as far as abuse of dominance was concerned. It was quite a difficult exercise. It certainly wasn't a consensus building exercise vis-a-vis the US. However, in practice, I'm not sure whether the cases dealt with on either side have ended up in a radical difference of result in the US and the EU, despite the fact that we disagreed on policy, which is interesting. So there are cases where we can disagree on policy, but in fact, when we look at what we actually did, it isn't that different. It reminds me of what my father always said about his Welsh mother-in-law: don't listen to what she says, see what she does. And there's a lot of convergence going on there.
Interesting. Yeah, I'll just add a couple. Can I add a comment? Just a quick couple comments on that. I think generally speaking, we should, to avoid these conflicts, we should actively promote convergence to the largest extent we possibly can. There have been attempts to sort of use a hammer in the past where there's not convergence. I mean, one of the great historical examples are the sort of clawback remedies for treble damages, and that was attempted to sort of respond to what was perceived to be extravagant jurisdictional claims by the United States. I don't know that changed our position particularly, but it was certainly a very, very strong message of we don't like the direction that you're headed. So, I mean, I suppose you could try something like that if you really got upset about the level, but I can't imagine that would be viewed as with any great success. So what I think really matters is to try to work on convergence to the degree that you can, and have really genuine, effective engagement, dialogue, consultation, and creating standards about what are the best practices, not only on due process but also on substance.
Let me just add one thing. At the basis, I think that most jurisdiction is doing the same. But what changed sometimes is the view of each agent has about the issue, the goal of antitrust. For me, it's very clear, because when I sit with DG Comp, with FTC, DOJ, and talk about antitrust. And when I go to BRICS conference, it's different. It's different. So the things that BRICS are concerned change a little bit. So, and when the countries is very different, the cooperation is going to be different. When they are not, it's going to be easier to find the good remedy that could apply for everybody. So this is a huge difference.
We have a last question there, I believe.
This is a question for Roger, George Willingmeyer. Hello. Hello, George Willingmeyer, GTW Associate. Certainly one takeaway, couple of takeaways I'm getting is little changes can make a dramatic impact, and also that what's happening in the U.S. might influence other countries. A couple of you have mentioned the Federal Trade Commission. Can Roger say anything about the DOJ point of view with respect to activities in the Federal Trade Commission?
Sure. Yeah, I mean, I do. On your first point, I absolutely agree that small changes can be incredibly significant. In fact, I actually think that's the way the world works generally. There's a favorite quote, leg over leg. It's a poem actually, but the leg over leg, the dog goes to Dover. The only way that you do anything is one step after another step after another step. Occasionally you have to make a big step. So I think the end of the poem is when he reaches the sty, he jumps over. You know, so there's a sty is the thing you step over on a fence. But you know, sometimes you make big steps, right? But mostly you make small steps in life, right? But recognize that those small steps are significant, right? And we were just talking about that recently in India, the DOJ folks, in which you basically look, you know, the DOJ was instrumental, FTC and DOJ were instrumental in establishing the ICN, right? And it's only been, what, has it been 17 years? Something like 17 years?
16 years.
It's incredible to see what's happened in 17 years compared to where we were. And so it is a real network of relationships that have developed, and those are significant and worth noting. So small steps matter, and I absolutely agree with that. With respect to the FTC, I mean, look, they have been a real leader on international engagement, right? They're incredibly active at ICN, right? And the amount of hours that they spend on the phone dealing with questions about sort of how are we going to draft this, or how are we going to work on that, or how are we going to organize that event conference is really, you know, noteworthy and commendable. And so, and they have a larger staff, they have a larger budget than the DOJ, and so anytime I want more money or want more staff, I just say, oh, we at a minimum, we need to have the same budget and the same staff as the FTC International Section, right? So yeah, I mean, I think it's been a close cooperative relationship.
Before closing, I'll just add to that, Roger, that the FTC has been more consistent in maintaining a high degree of involvement in international affairs. There were times, including, I believe, much of the previous administration, where there was no international deputy. So you are reinstating and representing the department's renewed commitment to engagement in this area. Please join me in thanking this terrific panel.